1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်541ဒေါ်ခင်ကြည် Widow of ဦးဘ Deceased and 1 Applicants vs ဒေါ်မမ Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Application before Dr. Mauma Chief Judge and ဦးသက်ဖေ Judge ဒေါ်ခင်ကြည် Widow of ဦးဘ Deceased and 1 Applicants vs ဒေါ်မမ Respondent Union Judiciary Act Section 6 Construction of Will Plain and unambiguous language whether it shall receive its literal construction use of ambiguous words duty of court to ascertain the intention of the testator consideration of surrounding circumstances testator family relationship testator use of words in a particular sense construction sector duty of court to carry out the express intention of the testator whether the law favors intestacy either wholly or partially. Hell, it is cardinal rule of construction that where the language of a will is plain and unambiguous, it shall receive its literal construction without attempting to give any conjectural amendment, but where the words used are ambiguous, the duty of the court is to ascertain the intention of the testator, and in doing so, it is entitled and bound to bear in mind and consider other matters like surrounding circumstances, testator family relationship, and the probability that the testator would use words in a particular sense so as to arrive at a right construction of the will and to ascertain the meaning of the language used by the testator. Once the construction is settled, it is the duty of the court to carry out the intention expressed by the testator. Keystame and others versus Saraswati High MA AIR 1939 Madras 112 Bridge Raj Singh vs Shatra Tranjai Singh AIR 1947 Out 45 refer to and follow. The general rule of construction of a will is that the law does not favor intestacy either wholly or partially. A will should not be construed so as to lead to partial intestacy unless the plain meaning of the words used therein makes it necessary to do so. Narendas and others versus Takchan and others AIR 1923 Cindy 42 SAS Radhanutame vs M. Arulanandam Pillai and others AIR 1946 Madras at 12 SM Vishni Bhai Alliance Hari Bhai WO Bhai Jamat Me vs Bhai Logu Me Satramdas and others AIR 1946 Cindy 108 refer to and follow. NC Sin for the applicants, Tan Tin for the respondent. Udape Judge, this application for special leave under Section 6 of the Union Judiciary Act arise under the following circumstances. 1. Domya, a Burmese Christian spinster and adoptive mother of the respondent, Domama, died on 27 September 1958, leaving a will by which the respondent was appointed the sole executive of her entire estate, to which the house and its site, known as numbered 72, 165 Street, Rangoon, hereinafter referred to as the suit property, falls apart. The respondent applying for and obtained probate of the will in spite of opposition by the late Uba, father of the applicants, who contended that the will did not affect the suit property, in respect of which Domya died intestate. It appeared that during the pendency of the probate proceedings, Uba took possession of the suit property, thereby necessitating the respondent to institute a suit in the Rangoon City Civil Code for declaration of ownership and for possession of the suit property. One of the questions that arose for consideration in the trial court was whether the suit property was the subject of deposition by the will of the late Domya. The relevant clause of the will, which has been the root cause of the dispute between the parties, reads, "Secondly, I give advice and bequeath to my sole adoptive daughter Mama, age 21 years, Burmese Christian, residing at 72, 165 Street, Damwe, Rangoon, and my legacy, all movables, as the said Mama was brought up and adopted by me from her babyhood when she was only 12 days old, with a view to inherit my estate to and for her own use and benefit absolutely and nominate, constitute, and appoint Mama, who is living with me." The learned trial judge took the view that there was latent ambiguity in the above wordings and therefore allowed extrinsic evidence which clearly showed that the testatrix intended to leave her entire estate, including the suit property, to the respondent. He accordingly decreed the respondent's suit, with cause the applicants came out on appeal to this court against the judgment and decree of the trial court, which were however confirmed by our learned brother Usain judge. After holding that the learned trial judge was perfectly right in admitting extrinsic evidence to explain the language of the will, which is latently ambiguous, the applicants, being aggrieved with the decree of the appellate court, has now sought permission for special leave to appeal. It is a cardinal rule of construction that where the language of a will is plain and unambiguous, it shall receive its literal construction without attempting to give any conjectural amendment. But where the words used are ambiguous, the duty of the court is to ascertain the intention of the testator, and in doing so, it is entitled and bound to bear in mind and consider other matters like surrounding circumstances, testator-family relationship, and the probability that the testator would use words in a particular sense so as to arrive at a right construction of the will, and to ascertain the meaning of the language used by the testator. Once the construction is settled, it is the duty of the court to carry out the intention expressed by the testator. The principle upon which a will should be construed have been succinctly stated thus in Kistame and others versus Saraswati by M.A. 1. Certain principles upon which a will should be construed are as follows. The first principle is that the code should give effect to the plain meaning of the words used. Secondly, if there is any ambiguity, the code should, in interpreting the language, lean towards carrying out the known intentions of the testator as far as they can be ascertained from the reciters and from the surrounding circumstances. Thirdly, in interpreting ambiguous words, the code should bear in mind the presumption that the testator was not likely to intend to create an intensity regarding the residues of the estate. Fourthly, the code should not strain the language of the will either in order to give effect to the apparent intention of the testator or in order to prevent an intensity. Finally, the code has no power to insert in the will a disposition which is missing, however desirable that disposition may be. In Bridge Rhyme Singh versus Shatranjai Singh 2, it has also been laid down that one of the cardinal principles governing the construction of wills is that the code should ascertain the dominant intention of the testator from the words used in the document and give effect to it to the extent and in the form which the law allows. The code is entitled and bound to bear in mind the surrounding circumstances, the testator manners, his outlook based on his particular religion and social custom, his position, his family relationship, the probability that he would use was in a particular sense and many other things which are summed in the expression. The code is entitled to put itself into the testator armchair. In the present case, the relevant portion of the will which deals with the disposition of the properties of the testatrix provides that, secondly, I give, devise, and bequeath to my sole adoptive daughter Mama, aged 21 years, Burmese Christian, residing at 72 165 Street, Damwe, Rangoon, and my legacy, all movables as the said Mama was brought up and adopted by me from babyhood when she was only 12 days old, with a view to inherit my estate to and for her own use and benefit absolutely, and I nominate, constitute, and appoint Mama, who is living with me. A careful reading of this passage shows that the purport of the word and appearing between the words Rangoon and my legacy is not altogether clear and unambiguous. The learned advocate for the applicants had in the course of his arguments submitted that the word and should be substituted by the word as, so as to make the meaning of the passage clear and correct. This is a tacit admission on the part of the learned advocate for the applicants that the meaning of the words used therein is ambiguous. Under the circumstances, it cannot possibly be said that the lower courts erred in admitting extrinsic evidence in construing the will of the late DAW KHIN KYI. Then if we were to construe the will of the late DAW KHIN KYI as suggested by the learned advocate for the applicants, it would result in partial intestacy of the estate of the testatrix. The general rule of construction of a will is that the law does not favor intestacy either wholly or partially. A will should not be construed so as to lead to partial intestacy unless the plain meaning of the words used therein makes it necessary to do so. Thus, it has been held in Narendas and others versus DAW KHIN and others 3 that in construing wills, the test is what did the testator mean having regard to the words used. One of the cardinal rules in construing a will is to avoid an intestacy, whether wholly or partially. It was also observed in SAS Ratanathame versus M. Arulanandam p.541 and others for that the general rule of construction of wills was that a will should not be so construed unless the plain wording makes it necessary to do so as to lead to an intestacy with regard to some part of the testator property. The same view has also been expressed in SM Vishni by Alliance, Hari by WO by Jamat Me versus by Logu Me, Satram and others 5. Besides it must also be borne in mind that special leave under Section 6 Union Judiciary Act will not, as a rule, be granted in the absence of any special circumstances, such as one of jurisdiction or doing of a great and irreparable injury or involving a question of great public or private importance. V.D. DAW KHIN KYI versus LK IR4 92 and 4 others say no such special circumstances are present in the instant case, inasmuch as the lower courts had, in our opinion, rightly interpreted the law relating to the construction of wills. The application is accordingly dismissed with costs, advocate fees, debt 85.